All right, future silks, welcome. If you're getting ready for the Queensland bar exams, you know that statutory interpretation is basically the whole game. So today, we're diving deep into one of the most fundamental and honestly, one of the most powerful tools you have, the AIA's definition of property. I mean, property. It seems obvious, right? You see a house, you see a car, you see cash in hand. Yep, that's property. But what about the right to sue someone? Or your shares in a company? What about a future benefit you might get from a superannuation fund? Suddenly, it's not so simple. And let me tell you, getting this right is absolutely crucial. This isn't just about memorizing a definition, it's a core skill for pretty much any problem question you're going to face. So let's break it down. So here's our plan. First, we'll look at the black letter law, what the Act actually says. Then we're going to unpack why it's so incredibly broad. After that, we'll see how the courts are actually using it in real cases, and we'll wrap it all up with a clear, step-by-step playbook you can take straight into your exams. Okay, let's start at the very beginning, at the source. And this isn't just any old definition. Think of this as the statutory super tool. It's the default meaning for property across all Queensland legislation. And here it is, straight out of Schedule 1 of the Acts Interpretation Act. It says, property means any legal or equitable estate or interest, whether present or future, vested or contingent or tangible or intangible, in real or personal property of any description, including money, and includes things in action. You really do need to know this. I mean, internalize it. Just look at the language the drafters used. Any, whether, of any description. Those words aren't there by accident. They were chosen to create a net that is as wide as humanly possible. So, the rule is, unless another act specifically carves out a different, narrower meaning, this is what property means. Period. And you know what? The Act doesn't even stop there. It actually builds a fortress around this main definition by defining the key words inside it. So interest isn't just an estate, it's also a right, power, or privilege. And estate isn't just about title, it covers claims, liens, charges, the whole shebang. It all works together to create this massive interconnected web of meaning that's designed to include, well, almost everything. So you have to ask, why? Why is it written this way? Let's move on and really unpack the blueprint behind this incredibly sweeping scope. This is where you see the practical power of each part of that definition. It's built on these dualities, legal and equitable, present and future, tangible and intangible. This means it catches stuff like a beneficiary's interest in a trust, which is equitable, or that superannuation benefit that hasn't paid out yet, which is future and contingent. And of course, it specifically ropes in those things in action, which is just a fancy term for rights you can enforce in court, like the right to sue for a debt or get insurance proceeds. And the big reason for all this? It's all about uniformity. By creating this single, powerful default definition, Parliament doesn't have to reinvent the wheel and define property in every single act. It's a safety net. It stops gaps from appearing and makes sure that complex, modern forms of wealth don't get left out just because of some narrow, old-school common law idea. The default is broad. If Parliament wants to be narrow, it has to go out of its way to say so. Okay, theory is great, but for your exams, you need to see how this stuff works in the wild. So let's look at how Queensland courts are actually picking up this tool and using it to solve real disputes. Our first case is Public Trustee v. Smith, and it deals with an asset that trips up a lot of people, superannuation. Is your interest in your super fund property before you actually retire and get the cash? So in this case, the court went straight to the AIA definition. Sure, the benefit wasn't tangible, you couldn't touch it, and it was contingent on the person's death. But what does the AIA say? It explicitly includes contingent and intangible interests. So boom, the court said, yes, it's property for the purposes of the will. This case is just a perfect demonstration of the definition doing exactly what it was made to do, to capture these modern, complex financial things. All right, next up, let's jump to a completely different area of law, native title. This is where you can really see the incredible flexibility of this definition. In Burns, the court had to figure out if native title rights could fit inside the statutory idea of property, which would then trigger a right to compensation. By looking to the AIA, the Court of Appeal was able to say, yes, these unique communal and spiritual rights can be understood as equitable interests in real property. This just shows that the definition isn't some static historical relic. It's a living, breathing tool that helps the law adapt to new and unique situations. And this whole broad approach taken in Queensland isn't just something they came up with on their own. It's actually supported by some really key guidance from the High Court. The case of Yanner v. Eaton gives us the philosophical backbone for all of this.
This quote is absolute gold. The High Court said that property isn't the thing itself, but a legal relationship with a thing. It's a bundle of rights. It's about what power the law allows you to have over something. And that way of thinking perfectly explains the logic behind the AIA's wording. It's designed to capture any legally recognized relationship with an asset, not just physical ownership of an object.
Okay, time to bring this all home. Let's turn this into a practical, repeatable strategy. When you're in an exam and you see the word property in a statute, here is your playbook for how to tackle it.
Just follow these 5 steps. 1. Always, always, always start with the AIA default definition. That's your home base. 2. Actively hunt for a contrary intention. Does the specific act you're looking at have its own definition that tries to narrow things down? 3. Don't forget about equity. If there's a trust involved or a future interest, remember it's included. 4. Think beyond the physical. Debts, shares, rights to sue, they're all in. And 5. Context is king. The AIA gives you the huge, broad canvas, but the specific act might be focused on just one little corner, like residential property, and that specific context will control the meaning.
So, if you only remember one thing from all of this, make it this. The AIA definition of property is designed to be as inclusive as possible by default. Your starting assumption should always be that the net has been cast incredibly wide.
And that really leads us to the final and most important question for you to think about as you keep studying. We know the default is broad, but where is that tipping point? At what moment does the legislative context of a specific act become so strong that it shows a contrary intention and pushes that big default definition aside? Nailing that distinction? Well, that's the next level of analysis, and mastering it is a huge step on your path to the bar.